Greetings and welcome back. This is Criminal Evidence. This is Chapter 15. We're talking self-incrimination today. I'm going to close up my book because I'm going to tell you what you need to know about self-incrimination. Self-incrimination is probably, next to the Fourth Amendment, my favorite discussion topics because it flows so well. It flows to me. It flows as easily as the Fourth Amendment to be able to walk through that analysis and ask the questions you need to ask to determine whether or not you have a self-incrimination problem. The first thing you need to understand about self-incrimination and the Fifth Amendment right is to understand, number one, when it attaches, right? When it attaches. Just like with the Fourth Amendment, when does it attach? So self-incrimination, number one, when is it attached? Well, number one, it's not going to attach ever if you're not dealing with a law enforcement, the government, essentially. So let's go back to Chapter 14 where we talked about the misplaced reliance doctrine. And the misplaced reliance doctrine told you that you need to watch out who you talk to. If you're talking to a random person who's not a state government official, that's your own fault. Now, if you're talking to someone who's a state government official and you know this, well then, and you continue to keep talking, doesn't matter, right? You told them no matter what. But you got to have a state government official. That's the first step. If you have the state government official, the federal government official, the government official, period, you need the state actor is what we call them in law school. All right, you got a state actor. That's step number one. Number two is, are you in custodial interrogation? Are you in custodial interrogation? If you're not, then you have nothing to worry about. I mean, you do have a lot to worry about. I'm sorry. Then you have no argument. This question, whether or not you're in custodial interrogation, is sometimes flip-flopped with the next question, is whether or not it was a testimonial statement. And we talked about testimonial statements before in the past about cross-examination. And testimonial just meaning that it's spoken from the mouth and it's meant to incriminate. You know, it's spoken from the mouth. It's a talk. It's words, and it can be written. It can be written, and it is designed to incriminate oneself. So, which way you want to structure that. If you want to go 1, state actor, 2, custodial interrogation, 3, is it testimonial? Or if you want to go 1, state actor, 2, is it testimonial, 3, is it custodial interrogation? It doesn't matter. The analysis is going to be the same. Those two just get flip-flopped. But anyways, let's just assume we're going to go 1, state actor, 2, custodial interrogation, 3, testimonial. Number 2, custodial interrogation is actually two things. It's custody plus interrogation, but we just call it custodial interrogation to kind of wrap that up. So state actor, number 1. Number 2, we have 2A and 2B, which is custody and interrogation. Custody is the same thing as arrest. It's the same thing. Probable cause, meaning would a reasonable person feel free to leave? Would a reasonable person feel free to terminate the encounter with the police? If no, then you're in custody, right? That's the same analysis that we talked about earlier when we talked about Terry stops and stuff like that. That same idea of like, do you feel free to leave? Now we switch the topic to interrogation. What is interrogation? Interrogation is questioning that is designed to elicit an incriminating response. Now, that's actually there's an express interrogation and then there's an implied interrogation. The express interrogation is simply, did you do it? Did you kill that person? Did you rob that person? Did you steal from that place? That's express interrogation, right? It's designed to elicit a incriminating response. It's direct, just like that. The implied part is a little bit different. It's a little bit harder to spot, but with the trained mind and enough practice, you can understand what implied means. It means that the officer had some subjective understanding of the suspect's particular sensitivities, and they said stuff that was designed to elicit and attack that sensitivity to elicit the incriminating response. You might be like, what does that mean? So we've all heard that question, that case about the inevitable discovery of the little girl's body. The officers were closing in on the body in the open fields, and during the same time that officers were searching for the body and they were closing in on it because of the way they were searching for the body, they were going to find it anyways. There was actually another occurrence going on. The police officers that were actually transporting the suspect, they were talking about the little girl. And they knew that the suspect actually had a particular sensitivity for the holidays and for family. And so they started talking out loud, the two officers, not talking to the defendant, not talking to the suspect who was sitting in the back seat but could hear. They started talking out loud. Man, holidays, wouldn't it be a shame to leave that girl out in the snow and to, not let her be made whole with her family? I mean, the family's already lost so much. I mean, they were saying these things like that were just so directed at the suspect, because they knew he knew, and they knew he would say it, and they didn't want he'd already invoked his right to an attorney. That was the other thing I want to tell you. He already invoked his right to an attorney, so they know they couldn't directly question him about it. So they talked out loud. They thought they would be coy about it, and that's actually what violated his right. And because they got that statement, they were, they then used that against him to say that he did it. Now, you might wonder, well, what about the body that was in a founding? Well, that was found under multiple different reasons, inevitable discovery being one. The other thing about self-incrimination is that it only suppresses the statement. It doesn't suppress the physical evidence you obtain. But we'll get to that in just a second. The fact is that interrogation can be both express and implied. So I'm going to walk through that for you one more time. Number one, do you have a state actor? If you have a state actor, was there custody? Yes or no? Custody means, essentially, does the person being held have a reasonable belief, or should they have a reasonable belief that they are free to terminate the encounter? And what would you look for in things like this? A lot of officers, if there's like 5 or 6 of them surrounding you, that doesn't feel like I'm free to leave. But if it's a basic stop because I was speeding, you're not free to leave, but the Supreme Court has already said that doesn't work. But if you're, walking downtown and the officer approaches you and asks for your ID, you can say no, because what reason does he have to approach you? Use your facts and circumstances. The second part of that question, the second part of that inquiry, is whether or not there is interrogation. And we know that it can be expressed, direct questioning, or it can be implied questioning, or what is considered as being statements made for the purpose of eliciting a, incriminating response. All right, so you've come to the conclusion there's a state actor, there was a custodial interrogation. The third question is whether or not the statement given was testimonial. Name, birth date, address, these things are not testimonial. That's basic information, and it completely doesn't apply. What about fingerprinting? Okay, well, he had, he was in custodial interrogation, which means right attached, but was he interrogated? Well, yeah, he was kind of interrogated, but he never answered, but he did give a fingerprint. Well, that doesn't matter because the fingerprint is not testimonial in nature. It's a fingerprint. Okay, all right. Well, he didn't have that, but okay, wait a minute. He did talk. Okay, what did he say? Well, they gave him this piece of paper, and they told him just to say it. Well, what did the piece of paper say? The piece of paper said, it read out, a poem from, Shakespeare. Was it incriminating? No, it was just his basic poem. Oh, well, I think they were just trying to get his voice. They wanted to hear his voice. And that's another thing. That's not testimonial. If you just want to hear the voice, you're not really worried about the substance of the statement, you just want to hear the voice, then that's not protected by the Fifth Amendment either. It has to be testimonial. It has to be something that could be used against you in court. And even if it's testimonial, I can still get it and not grant you your Fifth Amendment rights. If I grant you immunity, if I say I won't use it against you, well, then guess what? Fifth Amendment, oh well, because it can't be used against you. I'm not going to use it against you. If the statute of limitations have run, meaning like the time for me to prosecute you for the crime has already passed, then I can, get that from you and not have to worry about doing the whole Miranda thing. And third, statute of limitations, I'm sorry, I am going to reference my book. I just went blank there. I apologize. The statute of limitations, the immunity, and what was that last one? I apologize for missing out on that one. Double jeopardy. I apologize. There it is. I totally forgot about that. That's the random one. So statute of limitations is time for, time to prosecute you for the crimes already passed. If I tell you the statute of limitations already passed, you have to answer the question. I don't care if it's incriminating or not, I can't prosecute you. If I offer you immunity, I tell you I'm not going to use it against you. I won't prosecute you anyways, even though statute of limitations haven't passed. Again, you still have to answer the question. I don't have to do the whole Miranda thing. And double jeopardy. If you've already been prosecuted for what the incriminating statement is, if you say it again, I can't prosecute you again for it. Even if you've been acquitted before and now you come back, OJ is a good example of this actually. If OJ came back and said, you know what, damn right I did it. Well, guess what? No one can prosecute him because he's got double jeopardy. So, people, they could actually go arrest him right now. They wouldn't have probable cause to do it, but if they did have probable cause and somehow that question came up, he could say, you damn right I did it, and they couldn't do anything about it. So those are the circumstances in which, even though it's testimonial in nature, you still have to say that you still have to talk. All right, so let's say it's testimonial, you got custodial interrogation, you have Fifth Amendment actor. What now? What now? Well, you have to, the United States Supreme Court was pretty helpful about this. It's called Miranda v. Arizona. And they said, you know what, if you have that situation, this is what you need to do. You need to let the suspect know that they have a right to an attorney. If they can't afford one will be appointed to them. Anything that they say can be used against them in the court of law. And they have the right to remain silent. And you can do it any which way. You can do it in any order. But they pretty much said you have to tell them that. Now, what's very interesting, if you read the strict opinion in that case, they never said that you have to say those things. They just said you have to say something that has an effect. And if you're smart, you realize, you know what, we're not going to try to do anything different. The Supreme Court said this, we're going to adopt this. And that's what states have done. So, if you're in that situation, you have to give them the Miranda warnings, and that's what every state does, and you tell them, hey, you have the right to remain silent. Anything you say can and will be used against you in court of law. It doesn't always have to be will, by the way, but they do say will anyways. You have the right to have an attorney present during questioning. You have the right to attorney present now. And if you can't afford one will be appointed to you. That's the Fifth Amendment. And if you have those read to you, that means that most likely you're in a Fifth Amendment situation where you're going to be asked to elicit, say, incriminating evidence. Now, here we are. You've been Mirandized. What next? You start answering questions? Heck no, you don't. Don't answer those questions. And don't expect the suspect to answer them anyways. If he does or she does, okay, whatever. You've already Mirandized them. If you want to show that they waive those rights, knowing and voluntariness. It's the same knowing and voluntariness that we discussed earlier when we talked about consent. It's the same that applies here. It has to be knowing and voluntary. It doesn't have to be in writing, and it doesn't have to be on videotape, but those are the best ways to kind of show that it was knowing and voluntary, was that you have it in writing and you have it on videotape. All right, so what if I get a Fifth Amendment issue and then I don't get the Miranda, violate Fifth Amendment rights? What can I do next? Well, understand that, yes, you may have violated the Fifth Amendment, but if you were able to get some physical evidence from that testimony, from that statement, even though it violated the Fifth Amendment, you can still get the physical evidence in, because the fruit of the poisonous tree doctrine, which applies to the Fourth Amendment, doesn't apply in the same way to the testimony, because the Fifth Amendment was only written to protect the statement, the words, from self-incrimination. It wasn't designed to protect you from the physical evidence we obtain, they obtain. So the physical evidence can still come in, and you can still get that statement in. It all depends on when you get it in. Your book talks about impeachment. And yes, if the door is open in trial, and we talked about this with character evidence in the defendant, if the defendant opens the door in trial, then you can use that statement to impeach the defendant. But of course, the defendant has to open up the door, and usually the door is only going to be open if the defendant's sitting on a stand, and it's very rare to see the defendant sitting up there on the stand. That is what I want to talk about with regard to the Fifth Amendment and self-incrimination. What I want to really touch briefly on, real quick, is the difference between the right to remain silent and the right to have an attorney present, and what happens when each one is triggered. So if you get Mirandized, you have two rights. You have the right to remain silent, and you have the right to have an attorney. If you initiate the right to remain silent, you just stay silent. You can do it that way. And the officers will come back and forth over and over and over again and figure out whether or not you want to talk. Or you can express and say, I want to remain silent. Well, then that means to the officers, they have to leave, and then they can't come back for a little while. to start questioning you again. And when they do, they have to Mirandize you again. In order to go, it's best practice to do it that way. Or you can initiate conversation with them as well. That's the right to remain silent. Notice, you have to stay in that room when you initiate the right to remain silent. What happens if you invoke the right to remain to an attorney? That's the more protective one. In that situation, the officers have to remove you from the situation you're in. You can't stay in the interrogation room. You can't even stay in the police station. You have to be released back to a place where you are generally familiar with for a period of 2 weeks, 14 days. Very weird, but that was a Supreme Court rule. It has to be at least 2 weeks. And then after 2 weeks, you can initiate conversation again. You can initiate conversation over anything. But during those 2 weeks, you can't talk to them, you can't approach them or anything like that. You can only work with what you have, which is waiting 2 weeks and then approaching. Now notice, I said you have to release the suspect into a place that they're generally familiar with. Well, what if it's prison? That's it. You release them back to prison, or you release them back to jail. You leave them alone for 2 weeks. But, Professor Strawn, no, it's okay. They're there for 2 weeks. That's what they're used to. They're just put them back in general population, leave them alone for 2 weeks. And yeah, I understand that there's going to be correctional officers around, and that's a risk. But, at the end of the day, that's all you got. That's their general habitat, essentially. And that's pretty much what the Supreme Court said. So you put them in that situation for 2 weeks, and then you pick them back up, and then you do the whole thing over and over again. You do the whole shebang. That's chapter 15 in a nutshell. That's self-incrimination. There's a lot of information in this chapter, just like in every other chapter, that I don't cover over because we have a limited amount of time, and I try my best to make sure I don't go over my time. Please remember, you're responsible for knowing all this stuff. I've given you all the information that I think is really pertinent to this, what the general scope of this chapter was about, and I'll see you for chapter 16.